Remind you, we are recording and live streaming the argument, so please identify yourselves and your clients at the beginning of your argument. Each of you will have 20 minutes in which to present your case, but you're not obligated to use all that time. Appellant's counsel, you're responsible to watch the clock. I know you know the drill. And reserve as much time as you want for rebuttal. Also, please keep in mind we've read the briefs, we've conferenced the case, we've studied the record, and counsel for appellant, you may proceed.
May it please the court, my name is David Abney. I'm here today on behalf of the appellants and with Mr. Daniel Ortega, co-counsel, trial counsel. I've had some health issues with my left ear, left side of my neck, so I've been taking pain pills very regularly, which has brought me great enlightenment in many ways. I don't know if it will help with this particular appeal or not, but one of my main arguments at the beginning was the constitutionality of ARS Section 12-820.03. Unfortunately, in the Morales versus Coffey case, this court decided that the statute was constitutional. I filed a petition for review, so the issue on September 8, 2023. I haven't seen the response to that yet. Of course, I don't know what the state Supreme Court's going to do with it. The court has construed the statute before in the Glazer case, Glazer, but nobody raised the constitutionality of 12-820.03. I do not know if this court wants me to talk about that. I mean, I'd love to, but...
Why don't we talk about whether Rule 42 and the court's treatment of it gets us analytically to where we shouldn't have to deal with it? Could you please speak to that first, Mr. Abney?
I'll try to. I think that you have to worry about the conflict between a statute and the rule, because the way the statute's set up, it controls completely. It's mandatory. So when you have pronouncements from a trial court saying, well, I would have done this anyway, or I would have been inclined to do this anyway, to bifurcate anyway under 42, the trial court is not really dealing with the reality of the statute. The reality of the statute is the trial court has no jurisdiction to consider whether it's a discretionary call or not.
So your argument is the trial court wasn't meaningfully applying Rule 42B and therefore didn't make a meaningful finding as to prejudice.
Right. In fact, it couldn't make a finding. It could not, I would say, because the statute controls completely. If you say the statute is constitutional, then if certain requirements are met, the statute has to apply.
But it was briefed to the court that the statute might not be constitutional, so the court was making a decision in a world where the litigation might end up with the statute being constitutional or not, and the court knew that at the time it ruled, right?
Yes.
So maybe the court was ruling alternatively to protect its holding in the event the statute was or was not found to be constitutional?
I don't think you can do that sort of a hypothetical ruling. I think you have to consider the ruling in the context of what actually existed. In the context of what existed as far as the trial court was concerned, what it was mandatory, it was bound by the statute to rule the way it ruled.
Oh, but you argued that I'm sorry.
But just one more, I apologize.
Yeah, no, I didn't mean to step on you.
So no, if it's but if the statute turns out to be unconstitutional, then what you're left with is the analytic process the court claimed it followed at the time, which is applying Rule 42. If the statute were unconstitutional and therefore thrown out, the court would do exactly what it did here, wouldn't it?
It might, except for a few considerations. The special interrogatories, for instance, are based entirely on the statute. So you've got whether it would be bifurcated or not bifurcated, the whole process was skewed and thrown out of whack because you had the statute being used as the basis for the special interrogatories.
But the court's not bound by the special interrogatories either, is it?
I don't think that was ever briefed or considered.
Oh, okay.
I'm pretty sure a court would be bound by a special interrogatory answer.
As opposed to a general verdict, okay.
Yes, sir. Because it wouldn't have a special interrogatory, it's not a general verdict.
Well, my question was, you folks argued that it's unconstitutional.
Correct.
And bifurcation isn't mandatory.
Correct.
And the Superior Court said, well, I do think it's that, but alternatively, and this is where I struggle, you say that we shouldn't consider that. Trial courts all the time give alternative rulings, and then this court, under our case law, says, if we can affirm for any reason the trial court has given us, or even hasn't, we will. And in this case, the trial court actually did. So how do I say that Judge Cooper was, and I don't want to use the term, put words in your mouth, but flippantly said, oh, under Rule 42 too, because we've got the controlling statute. I think we do that all the time.
You do it often. The difficulty here is that this was done in the context and in the matrix of the statute, which came out in the special interrogatories and in the way that the entire trial was conducted. The trial was conducted on the basis of the bifurcation, and that these standards in the statute were what would be what would control the outcome. So to talk about an alternative ruling or not, it doesn't work in a situation where you wind up with special interrogatories that are really the statute itself. So the judge...
Let me clarify. It almost seems to me like you're arguing the entire statute is unconstitutional and not just the subsection dealing with the bifurcation.
Well,
you're not challenging the three prongs of the statute, are you, as being unconstitutional?
What I'm challenging is that they have no applicability. If you take out subsection B, which refers back to A, the only reason that what A matters is because of subsection B. You get rid of B, A doesn't matter.
But go back, put the Rule 42 umbrella over this again. Why wouldn't the court be well within its discretion to advise, to decide that's what the jury's going to be? I mean, if the court says this is appropriate to have bifurcation, and we're going to give you some instructions, and the instructions are going to be what the state has to prove. Here they are, 1, 2, 3.
But the trial court specifically said this statute is mandatory. They have to follow it.
Right.
So all the talk about Rule 42B is simply speculation. It's dicta. It doesn't matter to what actually happened. The trial court decided this on the basis that B was constitutional, and it followed B, which meant that it had to follow A as well. And in fact, by setting up A as the standard for what the jury, special interrogatories, the whole process became tainted. When you're trying to decide if a roadway is bad or good, the common law is very generous to plaintiffs. It says that the public entity has a duty to maintain a roadway that is reasonably safe for the motoring public. And that's really all these all these cases boil down to ever since 1926, over and over in various ways, but really very tightly to that idea. All you have to do is establish that the public entity's duty is that to make a roadway that's reasonably safe for the motoring public. That's what it all boils down to. But the special interrogatories go way beyond that. And you can have cases, as you know, you can have cases where you comply with general engineering standards and whatnot, and it still is not good enough under the common law. But that didn't happen here. The court used the statute, subpart A, as the template for the special interrogatories, which compounded the error of the unconstitutional statute.
So I think I know what you're going to say in my response to my question. But so assume hypothetically that we agreed that we were to write an opinion that declares the statute unconstitutional and disagree with our colleagues. Why would you receive a new trial when you've had a trial before a jury and the jury rejected on the evidence, on the conflicting evidence? Why would are you? Maybe let me clarify. Are you getting a new? Is it your position you would get a new trial?
Yes, and it would be a trial where the jury would be properly instructed. You would not have the special interrogatories. Plus, don't forget, one of our fundamental arguments is that what the trial jury did was against the weight of the evidence. Because if you go back to the statute itself, which was the basis of the special interrogatories, the government had to prove there was a plan or design that was prepared in conformance with generally accepted engineering or design standards that affect at the time of the preparation of the plan or design. But all you had here was an artifact left over for construction. The construction company had this place between the freeway where it could take equipment from one side to the other and back and forth, and that was just left over. And eventually it was sort of semi-paved with, detritus and whatnot packed down, but there was no plan or design. It was simply there, and they took advantage of it. So it doesn't fit the statute to begin with, and the jury's decision that it did is contrary to the weight of the evidence.
Let me take you back a little, because I didn't understand your argument to be really saying A can have no application, and B, the only way A has any application is under B. I had Jonathan Rose for contracts, and he taught us statutory interpretation under the UCC, and I have a little experience doing it myself. A is simply a statement of what the law is, that a public entity or public employee is not liable for an injury arising out of a plan or design, and it goes on. It makes no reference to B. It establishes a standard. B says the court shall have that separate trial, but that's something it seems to me the state could waive. If the state never brought the bifurcation motion, they could have done one trial, but your client is still subject to proving that immunity doesn't apply. That immunity isn't triggered by a bifurcation motion. That immunity exists independent. So help me with your statutory interpretation.
Well, first
Why
of
that
all,
wouldn't be the case.
well, first of all, as a foundational issue, the government has the burden to show qualified
I'm sorry,
immunity.
I misstated. I apologize.
And, in Arizona, as they say,
Sure.
going back to Stone versus Arizona Highway Commission in 1963, liability is a rule and immunity is the exception. But this first part here, what matters is we had a bifurcated trial. So we're under B, and B specifically says if there's an issue of fact about whether you met the requirements of A, then you have B. So they have to show that the government has to show that they met the requirements of A, and they didn't do that. They didn't show a plan or design.
Well, when did they show that? I mean, isn't that just kind of a prima facie showing
No.
to get the bifurcation? So they have to prove what, as a matter of law, summary judgment?
They have to
meet
set-
that?
They had to show there's material issues of fact, right?
Right. They have to show a plan or design prepared in conformance with these certain standards. And they have to show that's in effect at the time of the preparation. And then they have to show that they gave the public a reasonably adequate warning of any unreasonable dangers or conditions. They have to show at least three things under A to have A to prevail under A as a defense. They have to show
But I'm
that.
talking about to get the bifurcated trial, because there's a difference between prevailing and getting a bifurcated trial.
Well, yes.
All they have to do is basically come forward and say, your client couldn't prevail in a summary judgment motion on A because there's a material issue of fact.
Genuine issue of fact, that's right.
Okay, so are you arguing that they never made that showing?
No, they
And it
never
should have
did.
never been bifurcated?
Absolutely.
Okay.
They didn't show it, and they didn't show it to the jury either when push came to shove. And it was, this is the time now under these special interrogatories. You've got to prove these things to the jury, and they didn't do it. The evidence wasn't there.
But I understand you're saying the evidence wasn't there.
Right.
So you're saying there's zero evidence on which the jury verdict was based? Because what you're trying to do now, once you get into that, is set aside a jury verdict, and we know that's pretty tough in Arizona.
It's a horrible thing to try to do. And yes, but it's not zero. It's substantial. You have to show
It doesn't doing zero to you.
no substantial. I thought you were going to do a heart. I thought that was very nice, but it'd be.
You need
Thank you,
it.
Your Honor. You have to show that it was not supported by the substantial evidence did not support the jury, which is a lot easier to do than to show there's no evidence at all. I mean, they pushed hard to try to come up with something to justify after the fact that the government's using this thing as some sort of emergency crossover, planned emergency crossover. It was unplanned. It was simply, as I said, a construction artifact left over from what had happened originally.
But do you agree with me that we are bound to follow and apply the definitions set forth in the Glazer case by the Supreme Court? I mean, we're not just applying a plan or design. We're applying those words that they talked about, the methods and the methodologies.
Glazer's a great, all in all, I mean, I feel like I'm walking into a trap here, but Glazer's a great case. I mean, the language in it, the reasoning, and on page...
I mean, just to drill down more, but there was some of that here. I mean, there's at least some, maybe it doesn't, maybe in your mind it doesn't meet substantial evidence, but there's testimony that they took a look at it. They wanted to take out the old berms, if you will, take them out, and they wanted to replace them with two emergency crossovers. Somebody said, okay. Somebody said, let's do that. Somebody then said, let's go drop some pavement buildings that's on those things. I mean, so to say that there's no plan is I don't know. I mean,
It's not as defense lawyers like to say, everything I say is disingenuous. It's not disingenuous. There was no plan. There was no design that was prepared in conformity with the standards. There was simply this unplanned crossover, and they pretty much sort of left it alone. They compacted a little bit, maybe they added some stuff. That was basically it. And they said, well, it sort of conforms to our general guidelines. That's an after-the-fact sort of thing. The plan or design is supposed to come first. They didn't have it. It wasn't prepared in conformity with any
it
standards.
doesn't have to be stamped plans, does it? Like engineered, stamped?
It doesn't say stamp plans, but it has to be prepared in conformity with generally accepted engineering or design standards in effect at the time of the preparation of the plan or design. They never had a plan or design that they prepared. Never. They simply paved a little bit, added some aggregate and whatnot, and that's all they did. And they said, well, look, it sort of matches our general engineering standards. That's just not good enough.
So let me just go back, because this is an improvement, arguably. You've got this thing in the middle of the road that was
Right.
left there, and so they looked at it and said, okay, should we improve this in a way? And that's putting down the milled pavement and things like that. So if what the plan would be is putting down the milled pavement, thinking about maybe putting up a sign or not, and doing those things. That's what planning is in the design. And then they say, and the testimony was that it generally conformed with what their engineering and design standards were at the time, which is, that's how we handle these. I know it seems rather built on top of it, but how do we say as a matter of law it wasn't enough?
Well, it's a house of cards because the plan or design needs to come first, and it didn't. What they got, they inherited.
What plan? Do they have to plan? I mean, this crossover was there, right? And I
Right.
grant you. But when something's just there, do they have to go back to ground zero? Or can they say, look, we're just going to improve this thing that's there?
They need to come up with a plan or design that matches the general standards that exist at the time.
Okay.
Actually plan it out, design it out, and then go forward with it, which they didn't do. They simply inherited this artifact of the construction, what was left over from the construction, and pretty much left it alone. They didn't do much with it at all. It's only after the fact they're saying, well, you know what we did conform with sort of our general manual on these things, but that's not what this statute requires. It's much more specific. I believe it has to be construed with great specificity because it's trying to take away common law rights.
So now, and then the other thing is, don't we have a jury finding that this was not an unreasonably dangerous condition at this point?
Well,
Haven't we gotten that? A jury had to find all three. And we have, a finding that, no, this wasn't unreasonably dangerous. I struggle with, again, coming back to a jury verdict and one who's argued this both ways.
Well, the standard
how we
is,
get past that.
it sort of turns the language that has been used since 1926 upside down. It's basically, you have to prove that your roadway was reasonably safe for travel. And this is beyond reasonably safe for travel. This is a different kind of thing when you're trying to say that unreasonably dangerous hazards exist. That's not the same thing. Was it reasonably safe for travel? That's the standard. And this is taking language out of a statute that I believe is unconstitutional, but in any event, they didn't prove what they should have proved under the common law because they're using an unconstitutional statutory structure. This would have never been in front of the jury but for subsection B. Subsection B refers you back to A, and that's what you have to apply. I'm going to reserve my time.
Well, had it not been bifurcated, though, this would have been in front of the jury who heard the whole case, though.
Right, but
Yeah.
then again, if there were special interrogatories, I don't see what there would be a need for it, but it would be, was this roadway reasonably safe for travel by the motoring public? That's what the interrogatory would have been. It's different.
May it please the court, my name is Chris Davis on behalf of the state of Arizona. several things to get to. The 42B, the questioning right off the stop, I think, is controlling here. The court said in its minute entry specifically that it found in its discretion that Rule 42B, the state would suffer prejudice if this case was not bifurcated. It specifically made the determination outside the statute that they would have found bifurcation regardless. I understand that what the council's saying about shall versus may on B, but again, the construction that council was saying about A is not just in the matrix of B. A is in the matrix of Glazier. It's the statement of the common law and in itself. And Glazier set forth those standards by itself. B came after A. B was enacted after with a couple big verdicts that came in and that gave the bifurcation there. So the matrix of A was actually based off common law as it stands.
Counsel, could you briefly comment on your opposing counsel's argument that the court acknowledged that the statute controlled its hand here and sort of therefore rendering the 42B illusory?
Well, again, when you're getting to whether or not there's a conflict, basically the legislature can make rules that supplement statutory rules that supplement the rules, and it has to be whether or not it's contradictory. Does this make the court, bifurcate because of the shall language? It does, but it's not fatal to the constitutionality of it at all. It supplements it. It doesn't engulf the rule. It doesn't contradict the rule. It serves the same policy purpose of the rule, i.e. specifically as the... Yes, sir.
Counsel, you're harmonizing the statute with the rule. My question's a little different because what I understood Mr. Abney to be saying was that even though the court made a separate discretionary finding under Rule 42, I understood him to say that the court expressed that it felt that its hand was subjectively bound by the statute, thus making that finding illusory. So I'd like you to speak to the mind of the court on that and respond to his point in that regard.
Well, speaking to the mind of the court, I don't know if I could do that with any. Again, that goes when you look at the analysis. When you're looking at whether or not the statutory construction conflicts with the rule, and the way the case law works is you got to look to whether or not there's a procedural. Does it engulf the rule or conflict with it? I don't want to presume that I know what the court's mental status was on that, but the court said it was clear from the facts, just like in the Morales decision that came out. The court has found that the immunities clause, the government can control the structure and suits against the government in very specific instances. And the court has basically said through the immunities clause in Morales that in these issues of highway design, because you are dealing with complex engineering principles and you're dealing with incredibly sensitive areas on damages and sympathetic issues on damages, that the avoidance of prejudice is almost baked in on these types of cases. And so the 42B, it meets the purpose and policy of 42B automatically in that, and it doesn't change or swallow the rule or contradict it.
So it doesn't really matter if the court felt subjectively bound is kind of what I take from your two answers to that question. So with respect to the issue before the court, are we to assume that the enactment is procedural or is the enactment substantive? Because it's interesting, half of Seisinger versus Seibel is about that. You guys aren't talking about that in your briefs, which is very interesting to me. I'm wondering why the analysis never got there. What's your view?
My view is that the court here found that it was procedural, specifically in its minute entry.
Do you agree?
Well, obviously substantive means there's affecting a substantive right, and this is more procedural, and I believe that the court found that it was procedural, and thus we don't actually get to that analysis yet because you have to find a conflict before you get to that analysis.
Well,
so I'm not going to say that's something that should be determined now because I don't believe there was ever a conflict.
Okay, so it doesn't matter, but
right.
You seem to be agreeing that it's procedural, but we just shouldn't get there.
I don't think we have to
because there's not a conflict, so it doesn't matter.
There's no conflict.
Okay, thanks.
Counsel, go back to Rule 42 because unless I'm mistaken, the state did not request bifurcation under Rule 42, didn't even make it an alternative argument. The states went 100% on the statute. The statute requires this. There are material issues of fact. We're entitled to bifurcation. So hasn't the state waived any argument that we ought to apply Rule 42 now?
No, I don't believe so because it's what the court found. The court said independently of itself that it would do it on its own accord. I mean, that's what the trial judge said when looking at it. It's whether or not we raised or not. They said specifically that it's in their discretion. Further, the court, in its discretion, finds that under Rule 42, the state would suffer prejudice if the case were not bifurcated, which is one of the prongs of 42B. It's, whether or not there's, to avoid prejudice, which is the main thing in this. Also to expedite, because, and that's an important point too, is that, we have an immunity. That's an affirmative defense, the 12-8-2003. And there's an issue, we had some discussion here that was kind of conflating the two about the common law and the affirmative defense. design is an immunity. If we can show design under Glazier that there was a plan, that the plan met the general standards, there was no hazard, that's the affirmative defense. That's an immunity. And you don't get to the common law. The common law comes second. The analysis of common law, whether or not it was reasonably safe.
And you're saying then even if this was not bifurcated and this went to a all-in-one trial, the state would still have that defense available.
Without a doubt.
To prove those three prongs, correct?
Without a doubt. I mean, to put an example, an extreme example, say, put like a stop sign or a stop bar somewhere there's things within the MUTCD that set forth like distances. You say you have something that's a foot or 2 inches outside of what the rules may say. That is technically a design flaw, right, which you could argue does not permit the immunity. However, the next analysis is it reasonably safe? We would argue it's still reasonably safe. Even though there's a design flaw, it's reasonably safe. 1 inch doesn't change anything. So that's why it's important to understand the delineation between the affirmative defense and the common law. It was kind of conflated there for a second. So what the state did in this, we did file, in procedure, we filed a motion for summary judgment, and it was denied. And then the question was whether or not we had a duty to sign or warn. Well, in the prongs of Glazier, you don't get there unless you find there's a hazard. And that was the question of fact that was basically the court was saying we had to go to the trial over. But we had to prove the affirmative defense, but you never got to the duty to warn unless you could show there's a hazard. And we put those prongs to the jury in the interrogatories based off Glazier, and they never got past 3 because there's no hazard. And there was evidence in the record from John Latier that said there's no evidence of public misuse. So there's no prior accident history or anything of that nature to get to the point of the duty to warn.
Let me ask you, because counsel has argued that we really shouldn't consider the Rule 42 ruling because the Superior Court felt compelled to rule under the statute. Mm-hmm. Is there any case, the argument to me is tantamount to saying it's dicta at the Superior Court, which is not a concept. Any case that you're familiar with where we won't honor that alternative holding from the Superior Court? Because I'm not familiar with one. I'm just curious, and I'll ask counsel to comment too.
If you understand Your Honor's question, any case that we wouldn't honor, I'm not sure I understand.
The alternative holding. I find under A and I find under B. I'm just not familiar with that.
I'm not, for this briefing, that's not something we looked at on this particular issue. But I would say that, the Redenauer case, which was a similar, we had the Morales issue, which basically was dead on point, 42B versus 12A2003. The court found it was constitutional. But in prior rulings, we had the Redenauer case, which was a Supreme Court case. I was trying to look for a case that says, where the kind of decision was made, in one respect for the statute, for the court. There's like an element there. And most of these cases revolve around the admissibility of evidence, usually the evidentiary rules. And in Redenauer, kind of the legislature made an admissibility ruling on post-sale. It was a product design case, right? And changes made on product designs after, post-sale. There was a chronological issue between the court's rule and the statute, basically pre-injury, post-injury about admissibility of evidence. It really worked like a subsequent remedial measure. In that case, again, going to the harmonization, the court said flat out that it was constitutional because it advances the same public policy. I mean, that's the kind of analysis about. I understand it's difficult finding examples of but I think the Redenauer case is on point with where the legislature kind of makes a decision before the court can, and they found it was constitutional because it advances the same public policy. One, promoting remedial measures to provide safer products. So I think the Redenauer case is fairly on point with something like that. Despite beyond that, Your Honors, one of the issues that I think the court needs to consider is whether or not did the statute take away a power that the court already had, and obviously it doesn't. The court has the authority under 42B to bifurcate to avoid prejudice. And then again, with the evidence, Glazier asked for a plan of design. There was a myriad of evidence, a mountain of evidence for the court, for the jury to support the verdict. We had testimony from ADOT engineers. We had testimony from experts that showed specifically, one, in this case, DPS came and asked ADOT, because there was a construction thing, hey, we'd like to have some emergency crossovers put in on this road, just because we have some dike. There was a dike, that was where it was put on. And John Latier testified specifically. Maintenance came to him, said DPS wants this, and that's a plan, and that's consistent with ADOT and with how they promote these emergency crossovers. But also, there's a design element that meets Glacier 2, which was omitted from the briefing.
Before you
Yes,
move
sir.
on, because if we reach the constitutional issue, you said this doesn't take away a power of the court.
It does
because the
not.
court can do it. But the court could also deny it. And doesn't the statute take away the authority of the court to deny that motion?
And it's not fatal. If the court,
Why not?
because it's consistent. It promotes the same public policy for the rule. It doesn't engulf the rule or
But
contradict the rule.
That's going outside the plain language of the statute.
Well, it says shall versus
It
may.
doesn't say that. Yeah, if the legislature wanted to say that, they could have, but that's not what it says. It's,
I think when you, I'm sorry, Your Honor.
no, I don't see, okay, we just published opinion this court where we went into some victims' rights, where we went into several paragraphs on shall versus may. It's been a sort of a ongoing thing for decades about sometimes may can actually be shall, but I don't think, you're not arguing that under Rule 42 may means shall.
No, we did not argue that it was considered. No, we did not argue that.
It's a discretionary call under Rule 42.
Well, this thing is again, per the rule, it just means bifurcation, but the court still has discretion in the framework of how the trial can go, meaning that you can put all the affirmative defenses and all the common law defenses in phase one, and it's because it says separate and apart from damages, and we've seen that, and then it goes, phase two would just be pure damages, nothing else. Or you have the affirmative defense tried first, which is what we argued for and got in this case, was that if we have an immunity, there's no reason to go further. The court has discretion, at least on the structure on that as well. But again, I understand that, yes, that the shall versus may under 42B, it's been determined that in these cases under the immunities clause, that in highway design cases, given the sympathetic nature and the horrific damages and the tragedies that result, and the complexities of the engineering, this is, from an engineering side, this is a very simple case, but when you get in some other areas, it gets very complex, it's difficult, and it's tough to separate the complexities of the design from the sympathy, and they find that there's undue prejudice on the state in trying to defend these types of cases. And that was found in the two verdicts that came in under Glacier and Humphreys. They made that determination that it pretty much meets the standard at the beginning. But again, the court does have the discretion in this case, the court specifically found in and of itself, they would have granted 42B without the statutory language, but they still have the discretion in putting the affirmative defenses with the common law defense in the phase one, and then just doing the damages phase two.
What about, circling back to the facts?
Sure.
As Mr. Abney argued, there was this dike or berm or whatever you want to call it, but dirt, I guess a dirt crossing.
Yeah.
And it looks like, in my mind, what I've read from the record or understand is that basically the difference between that and what created the emergency crossover was the dropping of asphalt millings.
Yes.
Period. Is there anything more than just placing the millings on top of? Do we know whether there was some grading involved? Would they have at least done that, or is it's really just placement of the millings?
It's really there wouldn't be grading involved because it's a pre-existing structure, and they actually look for pre-existing structures because it's already there. The dike is there, and the dike still functions as designed. It's still a functioning dike for these roadways, and part of the point why you use the millings there anyway is the maintenance crews need to check on that dike, check the catch basins, make sure there's nothing like guarding it. And you want millings there because you can cause issues with driving the trucks, because it's only meant for emergency vehicles, police and maintenance. You can pull mud out into the roadway, which can cause a hazard. So they like to use pre-existing structures and like to put the millings down there. Now, as far as specifically for the design criteria there, that's pretty much, if there's a pre-existing structure, that's all you really need, is to put the millings down and make it so that you don't have to interfere with the functionality of the dike as it exists. It's just simpler. Yes, sir.
Well, were the dikes then part of the design? Are they on the?
The dike is a part of the original as-built design. That
Okay,
would
so
be
that
an
was
original
there
design.
Where it's at on purpose, but not for a crossover as a dike. And so it was part of the overall plan.
Well, the emergency crossover wasn't part of the original overall plan.
No, but the dike was.
The dike was, correct.
And the expectation that people would drive on that dike for the maintenance.
just maintenance and
Right,
just
but some
maintenance
vehicles-
and police officers, and they kind of know. And there's some testimony about codes in the road. There's sometimes there's raised by pavement markers. That emergency crews would know that it's there, and that goes back to the whole point of signage, which I know we're not talking about that here, but just for your edification, is that you don't want the public to know it exists. And so when you put up a sign, you don't put it up until last, unless you actually have a problem, because once they figure out it exists, they're already past it. So that's the kind of the purpose there. They don't want the public to know it exists. If you put up a sign, they know it's coming up, you know.
Well, my question, I don't know that we can get into it, but it's this turnout without, it was not intended for the general public to
Absolutely
use.
not.
But it sounds like, and I don't know if there's evidence of this, that there was an expectation people would slow down very significantly to turn onto it, whether it be a maintenance crew or police, just not the general public. Is that true?
Well,
And is there evidence in the record of that?
okay, obviously it'd have to be true for them to get into the area, but the roadway design guideline, RDG 401.5, which was evidence in this case, which is the design criteria, it's not complex, it's Exhibit 68 in the trial record, it actually says do not put in acceleration or deceleration lanes. So they don't want you to, again, it's only for maintenance and police. It's not for the public. And there's a difference, and there was some mischaracterization as the terminology.
Which is
Someone's
why you
calling it
showed
median opening versus emergency crossover. That's two very different things. Median openings are for the public. It does have to meet all kinds of radiuses and decelerations and all that, because you're inviting the public there. This is not for the public at all. So the criteria is very basic. Put Billings, don't have an acceleration, deceleration lane, keep it a certain distance from the next interchange, and that's it. But it is spelled out under 405.1, and it was introduced. And our expert, Tom Brand, said all design criteria of all three were
It has
met.
to be a mile from the nearest exit,
Yeah,
I think it is.
right.
And they have the little special dots to say, hey, 3 dots.
Yeah, and again, there is warning there because there's a yellow stripe, yellow paint, that goes straight across. There's nothing to invite the public in there. So there is a warning there. Again, the point is the public not to know it exists. But that's but all that evidence was introduced, and it was found, plenty of evidence to support the jury's determination in this case. We never had to get to whether or not there is a sign because there was no evidence of a hazard. We met that there was a plan, we met the standard of the plan, and we showed there was no hazard, pre-existing hazard, that would necessitate a warning. But again, and so we easily meet the criteria, the underlying jury's verdict. And again, the statute as it exists is fully constitutional because it does not contradict with the Rule 42 and it serves the same public policy purpose. If there's any other questions?
No.
Thank you, Your Honors.
Thank you, Counsel.
Judge Jacobs, your question, I think, was there an argument this was procedural versus substantive ever made? I think that the thrust of the government's argument throughout has been that it's procedural statute and a procedural rule. And that matters because procedural matters are entrusted to the Arizona Supreme Court. They're not entrusted to the legislature. So, that sort of makes my case. The only difficulty is...
It does, except for the fact that in this case, the court made the alternative finding of prejudice under Rule 42. Otherwise, you'd be right.
Well, the difficulty with that is the trial judge was bound by the statute. It's a mandatory statute. I've got to follow it. By the way, he probably would have done 42B bifurcation anyway.
But that's the problem for you. We have to treat that ruling as basically pretext. That's kind of what you're saying, is that the Rule 42 ruling is sort of pretextual or make weight or empty for some reason.
It's a basis for what the trial court did. And if it's unconstitutional, then it was a mistake for the trial court to have set up this bifurcated trial the way it was set up, and to allow the jury to focus on the language in Subpart A, which is tied in with Subpart B. The only way you get that language in Subpart A is if Subpart B pulls you back to Subpart A, and otherwise it shouldn't apply. We already know what the standard is, and the standard, of course, has been that standard that public entities have a duty to make sure that they provide reasonably safe roadways, predates our creation as a state, and it goes back hundreds of years. That's been the common law rule.
Thank you, Counsel.
Thank you, Your Honor.
Thank you both for your arguments and this morning. And the court will take this matter under advisement and issue a decision in due course.
Yes, Your Honor. Thank you.